Call it a dare, call it baiting, or maybe just calling his bluff. But both the prosecutors in Donald Trump's hush money case and his accuser, Stormy Daniels, are telling Trump that if he doesn't believe her testimony, just testify himself. Daniels is as biting on social media as she was on the stand, writing, "Real men respond to testimony by being sworn in and taking the stand in court." Oh, wait, never mind.
Everybody saw what happened today. I don't think we have to do any explaining. I'm not allowed to anyway because this judge is corrupt.
Of course, Judge Juan Merchan has pointed out that Trump can indeed explain by taking the stand. The gag order does not prohibit that. But then he would be subject to cross-examination. Joining me now, William Brennan, defense attorney and former attorney for Trump Organization, and Chuck Rosenberg and Jessica Roth are still with me. William, to testify or not to testify, that is the question. From a defense attorney's perspective and from the perspective of someone who knows Donald Trump, do you think there are conversations going on between him and his lawyers about the pros and cons of him taking the stand?
Well, good afternoon, Chris. Of course there are. As in any criminal case, the defense lawyers would speak to the client about whether or not he or she wishes to testify, because it's really one of about three decisions the client makes on their own. Whether or not to plead guilty or to have a trial is one, whether or not to have a judge trial or a jury trial, and then whether or not to testify. And that's usually the last decision that's made. So that decision probably will not be completely made until the prosecution rests. The defense puts on any evidence it may. The defense doesn't have to put any evidence on, but if they do, if the defendant in any case, this case included, testifies, that is usually the last thing the jury hears.
Do you see that as a realistic option, that after the prosecution rests, they just say, Your Honor, we don't believe they've made their case. We are not going to call any witnesses?
Well, that's a little different from not having a defendant testify. For instance, in federal court, at the conclusion of the government's case, defense lawyers make what's known as a Rule 29 motion. And you basically say, Judge, taking all of this evidence in the light most favorable to the government just simply hasn't made out a case. They are routinely denied, by and large. And then the defense can put on a case if it so chooses. There's no obligation under our Constitution for the defense to do anything. But they could put character witnesses on, they could put fact witnesses on, and then they could decide if the defendant the defendant himself or herself would decide if they wish to testify. But the jury, if the defendant elects not to testify, Judge Merchan in this case would tell the jury no adverse inference can be drawn from the fact you didn't hear from the defendant. Our Constitution guarantees a defendant the right to remain silent.
So as somebody who knows him and has worked with him, what kind of witness do you think he would be?
I think he'd be a lot better than people are prognosticating. He didn't get this far in life. For 4 years, he was the most powerful man in the world. He didn't get this far by not being able to handle himself. Having said that, I don't care who you are, the defense lawyers are probably sweating his testimony, not because it's him, but I know, and I've been trying cases for 35 years, your heart is in your mouth when a defendant testifies because, direct is usually relatively perfunctory and you rehearse it and you know what you're going to ask, you know what they're going to say. But for us, it's the Wild West. Anything can happen.